Welcome to this presentation covering the Fair Labor Standards Act. We've made good progress. We are now up to the child labor law section, so I'm going to fast forward to slide 79. And we will resume at this point. So we're going to talk about youth employment, and really there are two categories of youth. I guess you could say three, but one is pretty much not relevant to the business world, because those under the age of 14 are pretty much non-employable unless we're talking paper routes or something along those lines. So that's the first category, but for businesses that's essentially the null category. 14 and 15-year-olds are usually not employable either, because they are very, very limited in what they can do and the hours in which they can do it. So most of the activity with youth employment is going to be with 16 and 17-year-olds. Under federal law, 16 and 17-year-olds don't have any limitations upon the number of hours or the hours in which they can work. There are some limitations as to the particular tasks they can do. For example, they can't operate a service elevator, they can't operate a paper baler, and they can't climb a ladder. Those are three that sometimes do come up. So let's pause here and look at a website, the Department of Labor website, which gives a kind of a nice summary of this. So here, oops, sorry, wrong one. Here are the rules. If you were to go to the youthrules.gov website, this goes through the circumstances. So if I'm under 14, really can't do much of anything. You can deliver newspapers and babysit on a casual basis. If I'm 14 and 15, I can do several things, but you can see there's very much limitations as to when I can do it during the school year. And there's a lot of limitations as to the type of work that I can do. And then let's look at the main category, which is 16 and 17-year-olds. There's no limitations as to the time, but there are hazards that a youth is limited from doing. And of course, once I hit 18, there are no limitations anymore at all. So Youth Rules is a neat website for both employers and for people who are young, who might be interested in the rules regarding employment under those circumstances. Since most employers are not going to employ people other than 16 and 17-year-olds, this is probably the most important category, the things that 16 and 17-year-olds cannot do. Sometimes these tasks don't seem inherently risky, and so the youth may do them even after they're told not to do them, or someone might forget, hey, that person's really still 17 or something. And so it does require some training and some oversight to make sure there's compliance of these rules. Here are the actual limitations on hours of the folks under 16. I'm not going to expect that you know those particular time limits. State law controls in this area, and many states have much more burdensome requirements on employers in the area of child labor. For example, the hour limitations may extend beyond age 15, and they may have very significant fines if there's a violation, even if there's just a small technical violation. I've seen situations in which you have somebody working just a minute or two longer than what the person was supposed to work, and as a result there was a significant fine. As a result, many employers will intentionally schedule students so that they are scheduled to work at least an hour less than what they could work on that particular day. That way, if they don't clock out exactly when they're supposed to, they're not going to be in a situation where there's a violation. States also have some additional requirements. For example, it may be necessary for the employer to follow the school calendar in that particular jurisdiction. That can raise issues because it could be that your business location is in one school zone and the child may live in a different school zone. Or it could be that the child is homeschooled or perhaps has dropped out of school. And so really those rules may not fully apply to him or her. So if you encounter a situation like that, it's probably a good idea to contact an attorney or possibly to reach out to the state agency to see how those types of situations ought to be handled. Another common thing that we see in this area are work permits. These can present themselves in lots of different ways. Usually they're going to be something that the student goes to the school and requests, and with this document the student is then permitted to work. It gives kind of a certified record of the student's age and sometimes the school where the student attends, so that can be coordinated with whatever the rules are in that particular state about school attendance. Texas does not require work permits, and so that's not an issue here, but of course you may be working for an employer who has units in other states, so you need to be aware of that. Generally, child labor laws in Texas are not more restrictive than federal laws. In fact, the reverse is true. So we don't get a lot of attention here in Texas on child labor, but just be aware if you move to a different state, the result could be significantly different. And later on in this presentation, I'm going to show you some more Texas-specific information. So that's the end of our federal child labor section. We'll talk more about child labor down when we get to Texas. So let's move on to the Equal Pay Act. I'm not going to spend much time on this because we have a significant amount that we'll cover in the sex discrimination section on the Equal Pay Act. But here's just a very brief reminder of some of the things that we talk about in that module. The Equal Pay Act is an amendment to the Fair Labor Standards Act. It was passed in 1963, which is a year before the Civil Rights Act of 1964 was passed. Not surprisingly, since 63 comes before 64, right? This was really the first law that was designed to address a gender discrimination, and it's not nearly as broad a statute as a Title VII is with respect to gender discrimination. It's kind of the first attempt, I guess you could say, of legislating in this area. And it was really designed to address situations where men and women were doing pretty much the same job, and the employer paid men or women, possibly, but usually it was men, significantly more money for doing the same work. And that, of course, became illegal in 1963 and eventually became illegal again in 1964. So it really individual who is a victim of wage discrimination based upon gender can sue under either one or both of those statutes. Here's a little overview about how to prove that prima facie case. We've talked about prima facie case before. You can see this is the same standard that we saw under Title VII. Okay, we need to have one or more persons of the opposite sex working in the same establishment. In other words, you have a comparator of the opposite sex. You may recall in the prima facie case examples that we talked about under Title VII, you had to prove that a person was in a protected class. Well, in this situation, the person is proving they're a member of a protected gender, which is, of course, a protected class. Then you have to show that there's some type of adverse action. In this case, it is the higher pay that the person is receiving. And then you need to prove that the person is qualified. Well, presumably because the person is already doing the job, that's kind of not necessary to prove that. But here we're getting at the idea that the work is substantially equal. Now, there are some exceptions, some situations in which the employer can will not be held to be liable. One is if there's a seniority system, and we'll say the male is more highly compensated. Let's say the male has just been working there for a longer period of time. Or let's say there's a merit pay system and the male has just performed better. He's more productive, he's more precise in his work, whatever the standard is, he's doing better at it. Or it could be that he produces more work. Maybe it's not better work, it's just more work. Or it could be some other factor. He's the boss's son, for example, or boss's child, I guess I should say. So those are differences that could be supported and would not be evidence of the Equal Pay Act. Now, even though we usually think about women being the beneficiaries of the Equal Pay Act, there's no reason why a man couldn't make an Equal Pay Act claim. And there's no need that the titles of the men and the women incumbents in the positions have to be the same. It's not unusual, especially historically, it wasn't unusual, for two positions that were quite similar to have different names associated with them, and such that women typically were segregated into this job and men were typically segregated into that job. That the titles themselves is not controlling. Again, we talked about comparators. These are the individuals of the opposite sex who are being paid more than the plaintiff. The process by which you evaluate whether this situation is right, whether the jobs really are comparative, would be a job evaluation. And we've already talked about the prima facie case. Generally speaking, you are not supposed to have pay secrecy policies. You can't have it under labor law, under the NLRA, and you can't have it under the EPA. The idea is, how is a person supposed to know that he or she has been the victim of some type of discrimination if he or she can't get information about what other people earn? Now, of course, this doesn't mean that the employer can or should publicize the pay of other individuals. It also doesn't mean that I'm required to tell other people what I'm earning. It just means that I can't be disciplined if I happen to volunteer that information. So that's an important thing to keep in mind. Many employers think, especially unsophisticated employers, think that they can require their employees to keep that information confidential, and they can take disciplinary action if the employee doesn't. That is incorrect. So we are now done with the Equal Pay Act, and now we're ready for the Texas-specific wage information. Please pay particular attention to this because this is Texas-specific, and so it won't necessarily be in other resources that you might be looking at. But your best source for this information is obviously this PowerPoint in this lecture. So let's look first of all at the Texas child labor law. So Texas does limit the work hours of 15 and 17-year-olds, but the limitations, as we'll see in a second, are less restricted than the FLSA. So when the state law is less restricted than the FLSA controls. In jurisdictions where the state law is more restrictive, or in other words, more protective of the minors, then that the state law will control over the FLSA. So in our case, the Texas law really doesn't have any impact. And you may be wondering, well, why do we have a law that doesn't have any applicability? It could be that our law predates the FLSA, although I think that's unlikely. I think a more likely explanation is that there are some very small category of jobs that may not be covered by the FLSA because they don't involve interstate commerce. And so this was an attempt by the Texas legislature to some extent regulate that type of employment by minors. As I said before, Texas does not require a youth permit. Here's our statute. I just copied it out of here, and we can see that a 14 or 15-year-old can work up to 8 hours a day, up to 48 hours a week. And these are the hours that he or she can work. I'm going to show the statute now. Here we go. Not the statute. This is the statute. I'm going to show you the Texas website. So this is the agency that handles child labor claims is the Texas Workforce Commission. So I have here the Texas Child Labor Law section here. And you can see they talk about prohibited occupations for 14 and 15-year-olds. I'm going to scroll down so you can see here. And it talks about the various, the hours that they can work. And you can see they contrast it with the federal law. And they talk about permitted professions for 14 and 15-year-olds and prohibited professions for 14 and 15-year-olds. And then here they have prohibited ones for 16 and 17-year-olds. So that's kind of an overview. I'm not going to expect you to know any of these details. As I said before, really in this area, federal law is going to be the controlling source. So let's talk about payday issues. This is one of the areas that we do see that there are some requirements under state law that we don't see under federal law. One of the requirements is that if a person is salaried or exempt, he or she must be paid at least once a month. In some states, the payment requirement is more frequent than that. Non-exempt employees, in other words, we're talking about hourly or commissioned, in other words, non-management employees, need to be paid at least twice a month. And these dates need to be specified, put on a poster that's available for employees to see. Here is the statute, so you can see the exempt workers need to be paid at least once a month. If they're non-exempt, around the 1st and the 15th, and a poster needs to be posted to that effect. Let's talk about discharge situations. If a person is discharged, he or she can expect to be paid or should be paid by the 6th day after the employment ended. I think I talked previously about the law in California, which requires that payment be made immediately. And what as a practical matter happens is that the employer in California doesn't actually process the termination until he or she gets the check. In Texas, because we have 6 days to process it, usually the employee is in a willful, in a theft situation or something that's a very clear cut, you got to fire the person situation. In most cases in Texas, you're probably going to go ahead and fire them once you've decided that's the right course of action, and then you can mail a check. There really usually isn't a need to delay communicating the decision since you have enough time to get the check into that person's hands. So this is the rule that applies when a person is discharged, but when a person resigns, you just have to pay them by the usual next date. So you process their pay just like you would anybody else. And finally, in Texas, the employer has to follow whatever the agreement is between the employee and the employer about how commissions and bonuses ought to be paid. This can be a source of tension in these type of situations. I've seen it percolate up when an employer has a complex pay system, and maybe the employee wasn't really fully understanding it. And so when his or her employment ends, he or she has a different understanding about how the commissions will be paid. In most of these cases, the Texas Workforce Commission referee is going to err on the side of hearing the employee out. I mean, for a lot of reasons. For one reason, whoever is coming back and saying, well, no, that's not what we said, has done this presentation 50 times and he really doesn't remember what he said to this particular worker. Number one. Number two, there's a pretty reasonable chance that whoever communicated his employee may not even be employed there anymore. And number three, just generally speaking, in the Texas Workforce Commission or any similar agency, there is definitely a sense that the employee gets the benefit of the doubt. After all, the employee is the one who is kind of out of work. And so as a result, it's a good idea, especially when you're talking about rather complex payment strategies, to actually have it written out very precisely, have an attorney review it, and have the employee sign it and date it so there can be no question. So even if the employee says, well, that's not what I was told, well, but you signed this document, and this document explains the procedure. You also want the actual document to be relatively easy to understand. If you can't explain the pay system within a page, it's probably not a very good pay system, because the goal of a pay system is to motivate the employee to do the things you want the employee to do, and you want the motivation to be lawful. Well, if it's so complicated the employee routinely doesn't understand it, it's not very motivating. So if it can't be done simply and transparently within a page, probably within half a page, it's probably something that would benefit from more work. And here is the information about the 6-day discharge, the next regularly paid payday, and then here's the information about payment of bonuses, etc. So I'm going to show you the Texas payday statute information. It's the same agency that does child labor. It's the Texas Workforce Commission. And you can see here we have the final payment. Within 6 calendar days of discharge, if the person resigns, it's the next regularly scheduled payday. And we can see up here here we have vacation is not required to be offered. If the employer offers those benefits in writing, the employer has to follow whatever his or her policy is. So if you offer vacation pay, you can't change your mind. Now, one thing that comes up in this area is, let's say that you happen to have a vacation system in which vacation pay, say it accrues, on January 1st. So you get, let's say, all employees get 2 weeks of vacation kind of put in their bucket on January 1st. The employee quits on December 29th. He's worked virtually the entire time. Maybe he's even given 2 weeks notice. So he really does think he's going to work into the next year. And he perhaps is counting on getting those 2 weeks of pay at the end of his employment. Well, the employer can go ahead and accept his resignation effective immediately and not pay out that time, because according to the pay plan, for this employer, the 2 weeks is deposited on January 1st and he won't be employed on that day. I'm not suggesting that's a good policy or that's a smart way of handling those types of issues, but it is something that would be lawful under the Texas rule. Other states have different answers to that. Other states sometimes require some kind of accrual system, so it's not deposited, in one lump sum on January 1st, but it may be, if it's 10 days of vacation pay, maybe it, essentially is like, 7.5 hours a month or something like that, so that if he actually leaves on December 29th, he's going to essentially get, 9.5 days, maybe a little bit less than the 10 days that he would have gotten on January 1st. So at this time, we've covered all of our topics. Here's some things to remember. Be sure you're properly classifying your workers. Err on the side of designating them as hourly paid folks, because that is the safer course of action. And when they are salaried, make sure you do periodic audits to make sure that the salaried designation is still appropriate. Be sure that you're recording hours appropriately, that you're beginning and ending the time worked as that should be done, and that your supervisors and managers understand how to address irregularities when a worker clocks in early or clocks out late or works without necessarily the right authority to do so. Keep in mind that breaks, if they're under 20 minutes, need to be paid. In Texas, they don't have to be offered, but if they are offered, they need to be paid if they're under 20 minutes. Also keep in mind that the fact that meal periods should be at least 30 minutes. Well, I hope that you've enjoyed this presentation, that you found it helpful for you. As always, if you have questions about the material, please don't hesitate to contact me. My email is cgroover@collin.edu, or better yet, stop by. I'd be glad to talk to you in more detail about these topics. Thank you for your attention, and I hope that you have a wonderful day. Bye-bye.